So if you find that your ex has withdrawn contact or limited it, the best thing to do is to have a dialogue. I very much think a chat about what's happened is the best way forward. Alternatively, you could engage in mediation or suggest mediation. If not with a third-party facilitator, which a mediator is, maybe a family member can assist with the discussion, but try and find a forum so you can have a discussion about what's going to happen next. You know, children issues are sensitive and they'll go on for years if your children are young, so you want to find some way of dealing with that particular problem. And of course, as a very last resort, you could go and see a lawyer or make an application to the court. And the court, when it's considering an application, will put the welfare of the child front and centre. That's what's going to be important. It isn't the wishes and desires of the mother, and it may not even be the wishes and desires of the father, but it's what's going to be best for the child. Pursuing contact doesn't have to be part of any other process. It's a freestanding issue. So you may find that if you've been married or you've been through a divorce, you've dealt with finances, you can still return to the children issue. And very often it does come later down the track. And similarly, if you've never been married and you have an issue in relation to this, you can issue the proceedings at any point. I mean, as a parent, you don't need leave of the court to issue proceedings. You can pursue it right away, but you do have to try mediation. It's probably worth emphasising that any application to the court does have a requirement for mediation, so that has to be attempted first.